Zachary Webster, a former deputy, is now infamous for ruining the lives of more than 33 individuals by planting false evidence. Webster, the son of a well-respected law enforcement officer, began his career in 2015 as a deputy at the Liberty County Sheriff's Office. However, his time there was short-lived after allegations of sexual misconduct arose. In 2016, he joined the Jackson County Sheriff's Office, where he gained a reputation for his aggressive patrolling tactics and high number of drug-related arrests. In the summer of 2018, prosecutors in Marianna began raising concerns about Webster's conduct, citing discrepancies in his police reports and body camera footage. One particularly damning video showed Webster holding a plastic baggie before conducting a search, which led to the arrest of a woman for methamphetamine possession. This prompted an internal investigation, during which Webster was suspended and ultimately fired after a stash of drugs and paraphernalia was discovered in the trunk of his patrol car, seemingly prepared for planting. In 2019, after a lengthy investigation by the Florida Department of Law Enforcement, Webster was arrested for his actions. Now, many are eagerly awaiting his sentencing, hoping to see justice served for the corrupt officer who destroyed the lives of innocent people.
Here today, but did write a letter. It's a part of the record, and Mr. Emanuel. The evidence at trial demonstrated that the defendant planted methamphetamine or paraphernalia in each of these victims' cars under the guise of performing a lawful roadside search of their cars. He then falsified arrest reports and submitted them to the sheriff's office. These false records were later relied on in this very courthouse to prosecute these innocent victims for crimes they did not commit. And at the time of his suspension from the sheriff's office, he had a stash of more methamphetamine and more paraphernalia hidden in his patrol car for that very use. Now, Judge, the defendant's criminal conduct represents an egregious breach of the public trust. The state's first exhibit in this case was his identification card from the Jackson County Sheriff's Office. And I read an opening statement and in the record at trial, the oath that he swore to hold that badge and that ID card. And in democratic free societies, people voluntarily grant their government awesome powers that they deem necessary for public safety and protection.
Officers like Zachary Webster are prime examples of why public trust in police departments and government institutions, which are supposed to protect and serve, continues to erode. Webster faced serious charges, including Count 1, where he was found guilty of racketeering, and Count 10, where he was convicted of official misconduct related to Stephen Van. However, Count 11 resulted in a not guilty verdict. Currently, Zachary Webster is serving a 12 and a half-year prison sentence for falsely accusing innocent drivers of possessing methamphetamine. In addition, he has reached a settlement with 33 individuals whose lives were deeply impacted by his actions. The settlement resolves the federal lawsuits filed by these plaintiffs, who accused Webster and his former employer, the Jackson County Sheriff's Office, of violating their civil rights.
We've got a fully executed plea document that provided in pertinent part that he was to serve 75 days in jail, and he's going into jail today.
This is Sheriff Todd Pate, who was caught not once, but twice, driving under the influence, and this time, he caused an accident that injured another driver. On March 8, 2019, Sheriff Pate, aged 51, was arrested and charged with his second DUI after a crash that left another driver hurt. The investigation revealed that Pate had been stopped by an officer and released shortly before the incident. The case was handed over to Special Judge Janet Crocker and Special Prosecutor Blake Chambers, leading to Pate facing 9 charges, including first-degree assault, operating a motor vehicle under the influence, for counts of wanton endangerment, first and third-degree criminal mischief, and leaving the scene of an accident. In response to Pate's actions, the citizens of Breckinridge County, Kentucky, started a petition demanding his immediate resignation or removal from office without further compensation, citing his numerous offenses. They expressed their frustration, stating, Sheriff Pate has repeatedly broken the law by driving under the influence of alcohol, endangering the lives of the public and himself, and tampering with evidence. His actions have breached the trust and confidence of the public, and he has neglected his duty and responsibility as a law enforcement officer. Sheriff Pate has exhibited poor judgment, lack of self-discipline, and control, making him unfit to hold others accountable for their actions. He has violated his oath of office and no longer reflects the values of our community. He no longer has the trust and respect of the people he serves. While we wish him well in his future endeavors, we firmly believe that his immediate removal from the Sheriff's Department of Breckinridge County, Kentucky, is necessary for the safety and well-being of our community. Before the hearing, Pate expressed his willingness to accept a plea deal, which would have entailed 75 days of imprisonment with credit for time served. But this is where things get interesting.
Is that your phone, Mr. Pate?
Yes, it is.
You need to put it away.
Okay. I was just had
You need
a.
to put it away.
Okay.
It was already a bumpy start to Todd Pate's court hearing.
Can I make somewhat of a statement? That's
That is a yes or no.
The hearing started on rocky feet for Todd, but that's not all.
I did that March 8th when I drank and drove. Thank God I didn't kill anybody. But I want this court to know, I want the people to know, and I want the public to know that Todd Pate holds himself responsible for everything that he did. But it's hard for me to lay down and plead to felony charges that don't apply.
So I think we are back, Mr. Pate, and probably should have stayed in the place where we started. Again, I wanted to give you an opportunity to have further discussions with your attorney. But I
And I'm
think
sorry, ma'am, for
no,
doing
you
this.
don't have.
I'm sorry for.
What I need to, I think we're back to where we were before. Is it your intention today to enter this guilty plea? And I think we're at a yes or no place at that point.
Can I say one more thing? I think everybody in this room wants this over with. And if I could address Blake, I hope you learn from this case I'm not mad at you. I'm not in any way upset with you.
Mr. Pate,
Not that it
we
matters.
have reached that point now.
Okay.
This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny.
Certainly not the people who I think are here with you today, Mr.
No, they don't. I've broken everybody's heart. But it's hard for me when I see Mr. Chambers sitting over there smiling. Let me just plea and get it over with for everybody. Plea to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
Okay.
And this is probably
I think
unusual,
we're done.
but
At
let's
this
do
point in
it.
time, I think we're done. And so let me tell you where I think we are today, is that we have executed plea documents.
Todd, a former sheriff, once carried himself with an air of arrogance, acting as though he were untouchable, above reproach, and almighty in his role. But now, he's about to learn how the world looks from the other side, where power and privilege no longer shield him, and the consequences of his actions are very real.
I've already ruled at this point in time. We're done at this point in time, other than setting this for further hearing as to whether or not the Commonwealth can enforce this plea, whether or not the Commonwealth is going to choose to withdraw its plea offer, whether or not the Commonwealth can withdraw its plea, and then whether or not Mr. Pate can withdraw his plea. But at this point, we've got a fully executed plea document that provided in pertinent part that he was to serve 75 days in jail, and he's going into jail today.
He ended up serving only 29 days and paid an $800 fine.
Strictest sentencing and sanctions. Your Honor, please do not send me to prison. I have roamed, but I'm not ruined. I still have a lot of good left in me.
Sheriff Charlie Rada, once trusted to serve and protect, found himself in a scandal after being caught stealing thousands of dollars worth of confiscated evidence. The charges against Rada stemmed from allegations that he took money from drug dealers, claiming he intended to use it to help the community, such as planting memorial trees. He tried to defend himself by insisting that the money wasn't for personal gain, though prosecutors pointed out suspicious expenditures in Las Vegas. During sentencing, Rada's defense attorney, James Bolger, argued that his client was a decent person who had done his best to serve the community. However, Judge Patricia Cosgrove made it clear that Rada's actions had severely damaged the public's trust in law enforcement and mocked the sacrifices made by those who serve. Rada's defense also referenced other Ohio sheriffs who had faced similar charges in the past, such as Fairfield County Sheriff Gary Demistry, Athens County Sheriff Pat Kelly, Sandusky County Sheriff Kyle Over, Mahoning County Sheriff Phil Chance, and Allen County Sheriff Samuel Krish. Rada claimed that the stress of investigating the Rhoden family massacre in 2016 led him to develop a gambling addiction, which worsened his mental health. Judge Cosgrove acknowledged the trauma that law enforcement officers often face, including witnessing horrific events like death and torture. However, she emphasized that Rada had the opportunity to seek free counseling but chose not to, and that he could have sought help long before his actions spiraled out of control. In the end, Rada served only 29 days and was ordered to pay an $800 fine as part of his sentencing and sanctions. As he faced the consequences of his actions, Rada pleaded, "Please, do not send me to prison. I have remorse, but I'm not ruined. I still have a lot of good left in me." However, the damage had been done, and the public's trust was irreparably harmed.
You were not reimbursed until later. You see where the state believes that some of this is due to gambling. I mean, you're talking like over or almost $6,000 in a couple of months that you lost or expended on gambling.
And at that point, we were making almost $11,000 a month. And that again was from my checking account, where it should show my direct deposits, my wife directs deposits, and that it came from our debit cards where I retrieved that money.
Charlie's gambling addiction escalated to the point where he began gambling with stolen money from drug dealers.
As a sheriff of Ohio,
Sheriff Charles Rada was sentenced to 6.5 years in prison, of which he will serve 3, after pleading guilty to 5 charges, including theft in office and tampering with evidence. Kim Potter, a former police officer, made headlines after she fatally shot Dante Wright, a black motorist, during a traffic stop. On December 31st, 2021, she was sentenced to 22.5 years in prison. Potter, who had served as an officer for 26 years, claimed she mistakenly fired her gun instead of her taser during the April 2021 incident. She was found guilty of second-degree manslaughter and first-degree manslaughter by a jury in December 2021. Before the sentencing, Potter tearfully apologized to Wright's family, but they expressed their disappointment, stating that her tears were not enough to bring justice. The family's attorney criticized the judge's comments during sentencing, pointing to what they saw as a lack of compassion for the victim. Potter's trial took place amid the larger national conversation on policing and systemic racism, sparked by the killing of George Floyd by Minneapolis police officer Derek Chauvin in May 2020. Floyd's death led to months of protests across the country, with demonstrators calling for police reform and an end to the disproportionate killing of Black people by law enforcement. Potter's conviction and the death of Wright were seen as a rare instance of accountability for a police officer involved in the death of a Black person. According to Mapping Police Violence, a research group tracking police killings, officers are rarely charged and even more rarely convicted in such cases. Potter's case also highlighted concerns around police training and the use of force. During the trial, experts testified that Potter had been inadequately trained and made a series of errors leading to Wright's death. Potter testified in her own defense, claiming she intended to use her taser on Wright, but accidentally grabbed her gun instead. Prosecutors, however, argued that Potter had acted recklessly, emphasizing that she should have been aware of the differences in weight and feel between a gun and a taser.
Would Miss Potter please rise? I'm now going to read your verdicts as it will appear in the permanent court records of Hennepin County. In the matter of State of Minnesota versus Kimberly Potter, court file number 27 CR 21 7490, we, the jury, on the charge of manslaughter in the first degree while committing a misdemeanor on or about April 11, 2021, in Hennepin County, state of Minnesota, find the defendant guilty. And the verdict was agreed to at the hour of 11:40 a.m. and signed by the jury person on 12/23/21. The verdict on count 2 is we, the jury, on the charge of manslaughter in the second degree, culpable negligence on or about April 11, 2021, in Hennepin County, state of Minnesota, find the defendant guilty. And that verdict was agreed to at 10:30 a.m. on 12/21/21. Members of the jury, is this your true and correct verdict? So say you one, and so say you all.
Yes.
Okay, you may be seated.
Derek Chauvin, a former police officer, took the life of George Floyd over an alleged counterfeit $20 bill. On May 25, 2020, Floyd, a black man, died after Chauvin, who is white, used his knee to pin Floyd's neck to the ground for over 9 minutes. Video footage of the incident went viral, sparking worldwide protests against police brutality and racism. The judge's decision in Chauvin's case reinforced the principle that no one, not even law enforcement officials, is above the law and that individuals must be held accountable for their actions. Chauvin was sentenced to 22.5 years in prison after being found guilty of second-degree murder, third-degree murder, and second-degree manslaughter. He also pled guilty to a federal civil rights charge and was sentenced to an additional 21 years in federal prison, which he is serving concurrently with his state sentence. Chauvin's defense team argued that the trial should have been moved and that the jury should have been sequestered, citing the extensive pretrial publicity and unprecedented security measures, including the presence of the National Guard, surrounding the case.
As sentence for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd. You are granted credit for 199 days already served. Pay the mandatory surcharge of $78 to be paid from prison wages. You're prohibited from possessing firearms, ammunition, or explosives for the remainder of your life. Provide a DNA sample as required by law. Register as a predatory offender as required by law. And then you will receive a copy of the order and also the attached memorandum explaining the court's analysis. Anything further from the state?
If this needs to be said.
Derek Chauvin addressed the court, acknowledging the politically charged environment surrounding the case and expressing well wishes for George Floyd's children, hoping they would have the best life possible. However, he did not offer an apology for his actions. Chauvin's attorney requested a 20-year sentence, but the judge ultimately sentenced him to 22.5 years in prison.